And I think now we move on to the first session, and that will address cross-border healthcare, the state of play and challenges. And so it will address patients' right in cross-border healthcare, assessment and future developments. It will be presented by Corina Vasilescu. She's the Policy Officer, Healthcare System Unit, DG General for Health and Food Safety from the European Commission. And I must confess, I already had a view on your presentation, and it is very, very interesting. I must say, I already learned a tremendous lot of the work that you've done, and I think there will also be some surprises for many people listening outside what already is available, but what of course needs to be done as well. Thank you very much for coming.
Thank you very much for the warm welcome. Good morning, everyone. My name is Corina Vasilescu. I am a policy officer in the European Commission's Director General for Health and Food Safety in the Healthcare Systems Unit. It is my pleasure to present to you today the Cross-Border Healthcare Directive, also known as the Directive on Patients' Rights in Cross-Border Healthcare. The directive entered into force in April 2011, and the deadline for transposition of this directive into national law was in October 2013. The objective of today's presentation is really to walk you through some of the main provisions of the directive, and then to present to you an assessment that we have done on the European Commission side of where we are with the implementation of this directive, and then to look at some of the next steps that we have sketched out for ourselves. So without further ado, let me please kick off this presentation with the headline messages of the directive. So with the directive, the patient's rights to choose healthcare abroad have been increased and clarified, not only to choose this healthcare abroad, but also to be reimbursed for it at home. There should now be greater clarity in terms of what provisions exactly apply. There is also a significant increase in information to patients on cross-border rights and on health systems more generally. So what are their entitlements and what baskets of benefits are offered at home? More specifically, there is also a minimum set of patients' rights now established for all treatment delivered in the EU. So, for instance, there is the right to access your medical records. There is also non-discrimination for access to healthcare and also for pricing. There is also a right to lodge complaints and to access redress mechanisms. So this is just to name a few of the rights that are enshrined in the directive. Now, cross-border healthcare is not new. It goes back to the social security regulations from the 1970s. There, cross-border healthcare can clearly be either necessary care, so emergency care with the European health insurance card that I'm sure many of you are familiar with, and also planned care, for which normally patients have to apply for prior authorization via the so-called S2 or E112 form. Between 1997 and 2006, there was a large body of rulings, so European Court of Justice jurisprudence that was passed, and that developed additional rights based on free movement of patients. So some of the rulings, for instance, pointed out that healthcare is a service under the free movement of services, that patients can choose healthcare and the healthcare provider abroad, that the level of reimbursement is up to the cost of treatment at home, and that prior authorization is acceptable for certain treatments. There was an initial attempt to codify all this via the Services Directive, but then very early on it was clear that a separate piece of legislation was required. So following quite challenging negotiations in the Council of Ministers and the European Parliament, the directive was finally adopted in 2011, and now we will proceed to some of the provisions of this directive. So the first important set of provisions concern patient entitlements. The patients have the right to reimbursement when they receive healthcare in another EU member state, as long as that particular healthcare is included in the basket of benefits to which they are entitled at home. Also, the level of reimbursement should be up to the cost of treatment at home or the actual cost of treatment, whichever is lower. In terms of quality and safety standards, it is the legislation of the member state of treatment that applies, so not the member state of affiliation of the patient, the member state where the patient is insured in the social security system, but rather where the treatment is provided. So it's the legislation of the member state of treatment that applies. Now, another set of provisions of the directive look at prior authorization, and prior authorization is possible under Article 8.2 of the directive for either healthcare that requires an overnight stay or for highly specialized and cost-intensive healthcare. If this is subject to planning requirements, so there is an if there, the member states are normally required to notify to the Commission the categories of healthcare that fall under these criteria if they insist on introducing such a prior authorization system. Now, when you are a patient and you apply for prior authorization under the directive, your prior authorization can either be granted or refused. The authorization may indeed be refused if there is no undue delay. In terms of undue delay, this is a very interesting concept that is introduced by the directive, and I think it's worth pondering over its definition just a couple of seconds. So what is undue delay? Undue delay, as defined in the directive under Article 8.5, is a waiting time that exceeds a time limit which is medically justifiable based on an objective medical assessment of the patient's medical condition, the history and the course of patient's illness, the degree of pain, and also the nature of the patient's disability. So it's interesting that authorizations may be refused if there is no undue delay, but also that decision from the member state must be properly reasoned, which means it must also be subject to review and capable of being challenged in judicial proceedings. As mentioned by other speakers before me, the directive also introduces the requirement for member states to set up national contact points. National contact points are information centers, basically, that provide patients information on their cross-border rights. So what they do is they tell outgoing patients, patients who wish to access healthcare abroad, about their rights, about their entitlements, about reimbursements, the procedures that apply to reimbursements, and about appeal processes in case their reimbursement decision is perhaps liable to being challenged. Also, they should tell incoming patients, so patients who come to access treatment in the member state, about the quality of care and safety regime that applies in that particular member state, also about any complaints and redress mechanisms in case of harm. There is also a provision in the directive requiring healthcare providers to provide information to patients about treatment options, quality and safety, also the right to practice, so registration and authorization status of that healthcare provider, about professional liability or any other insurance that applies, about prices and prescriptions. If we move on now to another set of provisions of the directive, we can look at the rules of reimbursement, and these are indeed clarified. So the same fees apply to foreign patients as they would apply for domestic patients according to the directive. There are also reimbursement tariffs which are based on the cost of treatment at home for a public or contracted provider, as opposed to a private or non-contracted provider, in the sense that across the EU, in general, the reimbursement tariffs tend to be higher for public contracted providers than for private non-contracted providers. So this particular provision in the directive actually acts in the interest of patients to make sure that they get the best reimbursement tariff that they can get under the national law. There is also transparency that is required on reimbursement entitlements. So the member states should be clear to their patients which treatments are eligible for reimbursement and how much this reimbursement would be. Now, the directive is also heralding a number of procedural guarantees and a number of flanking measures that guarantee patients' rights in the EU. So as recalled earlier, there is a right of appeal on authorization and reimbursement decisions. There is also the right to transparent complaint procedures and also to seek redress. An important side note here is that all treatment must be covered by liability insurance or a similar guarantee. There is, of course, the right to privacy and also the right to access a copy of medical records, and the right to non-discrimination, both in terms of access to healthcare and in terms of pricing. So that is not overcharging foreign patients, for instance. a number of articles under the directive really focus on cooperation between health systems and fostering and enhancing this cooperation. So Article 11 of the directive is the legal basis for the implementing directive that was adopted in 2012 on the mutual recognition of prescriptions issued in another member state. There is also Article 12, which paves the way for the flagship project that is the European Reference Networks, that was also mentioned before me. Article 14 and 15 looks at cooperation in e-health and health technology assessment, which is indeed a very fruitful area of cooperation. And also Article 10.3 calls on the Commission to encourage member states to cooperate in healthcare provision in border regions and also to conclude agreements amongst themselves. I finish on this last one because I wish to share with you today just some of the scoping work that is ongoing at the moment within the European Commission. So on the basis of this Article 10.3, encouraging cooperation in border regions, we have launched a study that looks at high-cost capital investments in health. It's due early next year, so it should be published around that time. It looks really to assess the possible impacts on health services accessibility and also to look at options to pool resources for high-cost medical equipment investments, where overall efficiency gains are expected from the public payer perspective. So now let me move to some of the challenges and some of the next steps. Very briefly, the Eurobarometer was mentioned before. So indeed, end of last year, we commissioned a Eurobarometer, which is an EU-wide survey of citizens. And we asked citizens if they would be willing to travel to another EU country to receive medical treatment. And a third of the respondents answered yes. And when asked what are the reasons for this treatment, or why would you be willing to go, they said that the first reason was to receive treatment that is not available in their country. The second one was to receive better quality treatment. And the third, to receive treatment from a renowned specialist. We asked also, are you aware of the existence of the national contact points for cross-border healthcare in your country? And only 10% of respondents across EU28 were aware of the existence of an NCP in their country. We also asked respondents and citizens whether they felt informed. So not whether, to what extent they were informed, we could not really assess that, but we asked whether they felt informed about what healthcare they would have a right to get to be reimbursed for in their home country and also in another member state. So half of the respondents felt informed about their rights to treatment in their home country, but only 1 in 5 on average say they feel informed about their rights to treatment in another EU member state. So clearly, awareness about rights amongst patients is a real issue. And patients do face difficulties in grappling with their entitlements to healthcare, even at home. Now, there are a number of challenges or open questions that we have come across also in our consultations with national contact points and with other stakeholders, and I wish to share some of these with you today. For instance, in terms of reimbursement and authorization, there are still questions regarding how to best explain to patients what are their rights under both the Cross-Border Healthcare Directive and the Social Security regulations, Regulation 883/2004, the ones that date back to the 1970s. How do you assess undue delay, the concept that we explained earlier, in practice, and how to get to grips with this when explaining it to the patient? And how do patients know what their entitlements really are? Also, what is the tariff for reimbursement? This is a question that we look at very closely when assessing the transposition of the member states. What is the tariff to be used for incoming patients? And what is the relationship between the two? And how do you ensure non-discrimination in pricing? Also, what level of detail should be provided by national contact points when explaining to patients their rights? And how should the NCPs work together? What level of information would be useful in terms of quality and safety? How should this be given by healthcare providers, for instance? And how should this be presented? Now, there was a requirement on the European Commission to present a report on the implementation of the directive. that was enshrined in Article 20, subparagraph 1 of the directive, and this implementation report had to be presented to the European Parliament and to the Council by October this year. We were very fast and we published it on the 4th of September. It was also discussed during the informal meeting of health ministers in Luxembourg on the 25th of September. There was a very fruitful discussion on this topic. I will just very quickly run you through some of the main conclusions of the report in the interest of time. So it was found, indeed, also on the basis of the Eurobarometer results, that extremely low number of citizens are aware of their general rights to reimbursement under the directive. Also, there are some current systems of prior authorization, as mentioned by my commissioner's member of cabinet earlier. These systems of prior authorization are more extensive than the current number of requests appear to justify. So there is perhaps to a certain extent a misuse of the highly specialized and cost-intensive healthcare criterion. Also, it is not always very clear which treatments require prior authorization and which procedures apply in practice. So for patients, it is rather hard to navigate the prior authorization procedure and the specific sub-procedures coming out of that. It was also found and detected that some member states apply lower reimbursement tariffs than those used in the home member state. So this is a disincentive for citizens, and we do not believe this is in line with the directive. And also there were significant differences that were found between the national contact points in their performance and also in the quality of information that they provide to citizens. Now, what are the next steps for the European Commission? Well, there are two approaches. There is the top-down approach and the bottom-up approach. In terms of the top-down approach, we are very much engaged and focusing on looking at the legal measures introduced by the member states to transpose this directive. This checking of the member states' transposition is taking place in two phases. The first phase is a completeness check, where we look at whether member states transposing measures address all of the provisions of the directive. So it's more of a quantitative check. This phase is now nearing completion. The second phase is the compliance check stage, and this compliance check stage looks at to what extent the measures introduced by the member state correctly transpose the directive. So it's more of a qualitative check to see whether the directive has been correctly transposed by these provisions. In terms of the bottom-up approach, we are also organizing a network of national contact points meeting in December 2015. This is very important because we know that the patient representatives have a very, very valuable voice, and they are invited to share their views on the patient perspective. It's true that there is a vital role to play in monitoring the implementation of the directive on the ground by patient organizations. And to sum up the presentation, we believe that via this two-pronged, two-sided approach, we can leverage the directive for the benefit of all and raise the game of all actors to improve the standard across the board. So thank you for your attention, and I look forward to your questions.